What makes an invention legally patentable in Australia? Before you click away thinking, this is just legal jargon, stick with me. Whether you're an inventor, entrepreneur, or just curious about how the system works, understanding what can and can't be patented could save you money and years of heartache. Australian patent law is built on something pretty ancient, a law from 1624 called the Statute of Monopolies. Back then, the English monarch was handing out monopolies left and right. Parliament said, enough is enough, and passed this statute to stop most monopolies. They made an exception in Section 6 for genuine inventions. Australian patent law in 2026 still references this 400-year-old statute. The Section 18 of the Patents Act 1990 literally says an invention must be a manner of manufacture within the meaning of Section 6 of the Statute of Monopolies. So, how does a law from the age of horse-drawn carriages apply to AI, biotech, or software? Instead of trying to constantly rewrite the law every time technology advances, Australian courts have let the meaning evolve through case law. It's like having a living, breathing definition that adapts over time. The NRDC case is the landmark decision in Australian patent law. Scientists found a way to use a specific chemical to kill weeds without hurting the crops. They applied for a patent. The patent office said, no, you aren't making anything, you're just spraying a chemical on a field. A field isn't a vendable product. The High Court of Australia stepped in to answer the question whether it was necessary, as a condition for patentability, for a physical thing to be brought into existence or modified. In coming to their decision, the High Court established key principles that revolutionized Australian patent law. For something to be patentable, it needs an artificially created state of affairs, basically human intervention that changes something in the physical world, and economic utility. It needs to be useful in a practical, economic sense, not just artistic or abstract. In the NRDC case, the artificially created state of affairs was a weed-free cultivation of land. It had economic utility because it made farming more productive. So what does then mean for inventors today? The old rule used to be that you needed to create a physical product, something you could hold, sell, or ship. But NRDC changed this, where even a process could be patentable, even if it doesn't produce a thing. The key is that you're creating some observable, useful change in the world. The High Court explicitly said there's no exact verbal formula for what counts as patentable. They recognize that technology keeps evolving, and the law needs to evolve with it. This flexibility has allowed Australian patent law to adapt to fields like computer software, biotechnology, and medical treatments. So, if you think you are sitting on a potentially patentable invention, ask yourself, is it more than just an abstract idea or natural discovery? Does it involve human intervention creating something new or changing something that exists? Does it have practical economic utility and is not just artistic value? If you can answer yes to these, you might be onto something patentable. Look, patent law can seem intimidating, but at its heart, it's about a simple trade-off. Society gives you a temporary monopoly on your invention, and in exchange, you share your knowledge with the world. It's a system that has been driving innovation for centuries, even if it still references a law from Shakespeare's time. What areas of patent law do you think are pushing the boundaries of this definition? Comment below. Thanks for watching, and as always, keep imagining.